So, welcome everybody. We've got Matt Dixon, who's the president of the Chartered Institute of Patent Attorneys, with us today. Uh, the most enduring feature I can think of for Matt is that he's a Yorkshireman. Congratulations, Matt, and well done.
What makes you say
He's a
that,
patent
John?
attorney with nearly 30 years of experience. Say again?
What makes you say that, John? Are you not also a Yorkshireman? There's some
I am
bias
indeed.
there.
Uh, Dehns and HGF, amongst others. As I've said already, Matt is the president of the Chartered Institute of Patent Attorneys, and Matt continues to help innovative businesses as a patent attorney in his role at Cranach Patent Attorneys, where he's of counsel. And Matt also provides business consulting services to patent attorney firms. So sadly, I couldn't play the music from Ronnie Ripple and the Ripcords, but Matt, if you'd just like to give us a quick intro to yourself, in particular, the blend of physics with patents and with music.
Well, I saw that. So obviously we've done a bit of prep for this, and I saw you had that question there for me, John, and I thought, well, what's it all got to do with it? And it came. My idea was it's about teamwork. So I have a recollection when I was about 17 of playing in my first band, and you kind of look around and you go, "This is actually sounding really good," and you're there with a bunch of people that you quite like, and you're all doing your little bit, and it's turning into some great music, and it's a very, very nice feeling. And I think throughout my career, I've always enjoyed those kinds of situations where you're with a group of people. You're all doing your bit. It's not all about one individual. It's all about the contribution of the people in there, and together makes for something better. So yeah, there's the philosophy based on being in a band.
Brilliant. Thank you very much, Matt. Should have said, of course, I'm John Pryor, and this is Caroline Walton, and we're co-hosting Innovation Matters, a series of webinars focused on innovation in the UK. And where better to start than with the patent attorney profession and somebody expert in innovation himself. So Matt, very quickly then, what do you think is the current state of innovation in the UK, and how do we stack up versus our other competitor countries? How do we position ourselves in the world, do you think, from an innovation perspective?
Well, I think we've always got a tendency in the UK to be quite critical of ourselves and to moan, whether it's about the weather or anything else. But actually, we stack up pretty well in terms of global innovation. Um, WIPO do a global innovation index, and the UK is at number 4 in that across all of the countries of the United Nations. So that's not bad. Of course, everybody then goes, well, okay, so who's at number 1, 2, and 3? And that's the USA, Switzerland, and Sweden, not necessarily in that order. What I think is interesting about that positioning is where that comes from, is the quality of our universities. So we have, I mean, world-class universities in a very real sense, measurably world-class universities. And it also comes from our creative sectors. So film industry and the like. Music, obviously contributing there.
Music,
Yeah.
yeah.
Music, film, those kinds of industries. One of the things, so I had a meeting earlier, well, so last month now, with Darren Tang, who's Director General of WIPO. And we were talking about the UK. I'm name dropping now, aren't I? And we were talking about the UK. One of the things that I think is concerning about that Global Innovation Index is that we are behind all of those countries, and also France and Germany, which I tend to use as a benchmark locally, on all of the measures that relate to patents. So patent
Yeah.
filings. And I think in the UK, we are behind, particularly on international patent filing.
Mm,
So
yeah.
you will shortly see a paper from SEPA in support of the Society for Chemical Industries manifesto, and we've added in some patent stuff on that. And one of the trends here that over the last 20 years, UK patent applications by UK companies have halved. which is a worrying concept. And we are behind uh, any European comparator country in terms of our filings at the European Patent Office and in China, which are the two most important countries after the USA for foreign patent filings. So I think we are not doing enough to protect internationally overall. And we need to emphasize that and encourage that
That's really
as
interesting.
businesses.
I didn't realize the extent of those stats, Matt. And Caroline's got some questions on the on patenting and patent attorney, but very quickly, and given what you've just said, what more can be done to help innovative businesses in the UK, and what are patent attorneys doing to help businesses with their innovation, particularly SMEs?
So, what can be done to help patenting and to help businesses protect innovation? Um, well, I mean, we would say this, and we would always say this. You need to be talking to the patent attorneys. So, it's important for our profession to make ourselves accessible for companies to understand that that we're there to help, and that it isn't just about very large companies. We're there to help SME businesses as well, and
Yeah,
that can be done. So it's World IP Day on Friday, as you will well know,
yeah,
and for World IP Day, we're launching a patent pack for SMEs, which is just there giving a grounding on this is what it's about, this is what it looks like, and importantly, this is what it costs. Because experience suggests that people believe that patenting is expensive. When they find out what it does cost, they go, "Oh, I thought it was going to be more expensive than that." And we're told by the Legal Services Board that this is very common for any kind of legal advice. In general, people overestimate what it's going to cost. So their perception is they overestimate what it's going to cost. So we've tried to put out some costings there, and particularly costings for when you go to international protection, so that people are able to budget, able to anticipate what costs might look like. And I think that's one of the things that we need to be able to do is talk openly about
yeah.
costs.
Oh, I think that's
Um,
great. I think that'll be really helpful.
I do
Yeah,
as well. I mean, one of the things that obviously we talked about before we came on the call, and I'm kind of jumping ahead a little bit now because I know we are going to look at the report that's been published by the Intellectual Property Office recently on
mhm.
awareness, understanding, action, and non-use of IP in SMEs. And what I found sort of quite surprising about that, one of the things I found quite surprising was where companies go to obtain information about how to protect their innovation. And there was a table with percentages essentially in that report, isn't there? And that report concludes that 19% of the companies that were interviewed or surveyed would approach an IP attorney for that kind of information, whereas 20% would approach family and friends for that kind of information, which I thought was staggering. Whether or not that report can be truly relied upon, and whether that's actually factually right, I don't know. But I think it's great that that kind of education is being provided. And of course, turning to that report, obviously there were percentages and conclusions about the percentage of companies surveyed that don't make any use, recognise they've got IP, but then don't do anything in terms of taking steps to protect it. And the figures there were pretty staggering, and cost was the largest reason for that. So that you're right. I mean, there is this perception that patenting is expensive, that needs to, I think probably it's just education and those kind of thoughts.
Well, I think on those sources of information figures, and we talked about this briefly before, there's something a bit more going on with those figures, because it says only 30% would look at it, would do a Google search. And it's like, really? Like, surely anybody that's looking for information would be doing some kind of Google search
yeah,
and
yeah,
anyway. And I'm wondering, what is it that they're doing if they're not doing a bit of a search? So there's something going on there. What I was really pleased to see is those that do get information, when they talk to an IP attorney, so they talk to a patent attorney or a trademark attorney. Now, the number here, and I wrote it down, 82% said they found the information useful or very useful. So basically, a very high satisfaction rating there from people that do consult an IP attorney. And it was a similar level for those that talked to the IPO as well. The IPO had highlighted that. So once people are getting in touch with patent attorneys, they're generally pretty pleased with what they're getting.
Yeah.
And I think those barriers as well, in terms of cost. I mean, people talk about lack of time, cost, complexity. I don't think it signals a problem with cost necessarily. It's just those are the things that go on when you're running a business. You know, you've got a mind on cost. You've got a mind on you're busy doing lots of things. You know, and if you have to answer the question, well, why haven't you done it? Then those are things to answer.
Right, just picking up on costs. Quickly, we know that in Europe the micro SMEs have had a patent fee reduction, and there are quite attractive IP incentives, IP patenting and trademarking incentives in Europe that don't seem, and neither of those two seem to be available to UK SMEs or micro SMEs. Is that something that's planned? I mean, it seems to me like it's favourable if you're based in Europe, and it's not so good if you're based in the UK from that perspective at the moment.
Well, in terms of the patent office fees, the UK patent office fees, they are very low. Actually, potentially too low, because I think they give a false impression about the overall costs of patenting. And I think it's important for the patent office to cover its costs in that kind of way. But they're already very low, and I haven't worked this out, but I think they would be lower than the SME fees for the European Patent Office. So, but we have been lobbying the Intellectual Property Office to say, why can't you do what they do in France? So what they do in France is, if you file a national patent application, you can get your patent application searched by the European Patent Office, but at a reduced cost. It costs you about €500, whereas it would normally cost you, I think it's about €1,500 it would cost you if you went straight to the European Patent Office. So that is subsidised. The big advantage of that is when you go international, you file your international patent application, you can then get a reduction in the fee because you've already had that search done by the European Patent Office. And the UK office is already having patent applications searched by the EPO to deal with workload. So we're saying, well, give us the option to do it because it's beneficial. It means that rather than spending £3,000, you could be spending £1,500.
Yeah. Caroline, your question?
Yeah, I think just in relation to that, my understanding is that the EPO have basically reduced fees for micro-sized companies, so effectively to encourage startups. And I think they have also, am I right in saying that they've also taken out the need to pay fees for certain things as well? But generally speaking, they have increased fees, I think, for other companies. So the fees have gone up slightly. Am I right in saying that? So it is just micro startups they're encouraging.
I mean, the fees tend to go up annually, if not at all. But they're offering this reduction for very, very small businesses that continue to be very small businesses. It's something you've got to keep an eye on, that it continues to apply. And we shall see to what extent that gets taken up overall. But it's potentially it's a step in the right direction to encourage that.
I think one of the other things, I mean, just in terms of my experience of talking to companies carrying out R&D where they are a bit dubious about patenting, yes, there's always a question mark over cost, but it's length of time as well, the length of the process it takes to actually get a granted patent. And obviously, I know that in the UK there is we've got there's the green route, a way of accelerating obtaining a patent. Obviously, we know that with the government's overarching innovation strategy, that they are supporting, looking to drive innovation in certain sectors where they really want us to help the UK become a superpower. So sustainability being important, and also life sciences, etc. I mean, do you think that in terms of anything more could be done to actually introduce any other routes, to accelerate the actual patent filing process, similar to what you might do if you had green technology? Think anything like that could happen or could be promoted?
Well, I think it's important to understand actually what the timings do look like for patent applications. So you can file at the UK Patent Office. You can get yourself a search and an examination report together, coming back after about 4 months after you've filed. You can deal with that, and you can have your application ready for grant, and you can get a patent application granted within a year if you want to, which is a rapid timescale in the UK. And the main reason why you wouldn't do that is your patent application only gets published after 18 months, and in general, you don't want to put your technology into the public domain if you can help it. But there is a strategy that says get it granted in the UK early, so that you can prove that so you can demonstrate to third parties, be those potential competitors or investors, that you can get patents granted for this technology. Have an international patent application, so you're saying, and we can get it granted in 150 other countries. That looks pretty good. The kind of timescales that people get frustrated about is when it's taking 4 or 5 years to get to grant, and also the uncertainty of knowing whether or not you're going to get your patents granted when it's not looking clear. So if you can use that kind of strategy, get something granted early in the UK, go international, that can work well. And also, it's not always the best thing to get your patents granted early, because then you're locking in the protection that you've got. So you're saying, this is what we're going to have patents for. And it may be that you want to have things pending so that you can pivot. You might, a new competitive product comes along, or you work out, well, hang on a minute, we could cover this, and this seems more important. So you've got that flexibility. So that double-stranded strategy, I think, is a potentially good one. In terms of the green channel, I think, in my experience, the green channel doesn't actually speed things up that much, because it's a UK office thing, and the UK office is generally pretty quick. Overall, it's not, famously, India, for example, takes a very long time to get your patents granted. And also, if you're doing all of this quite quickly, it's bringing costs forward, so you're spreading costs over more time. So I think you want the option to be able to get things granted quickly, but it's not always the option that you want to choose overall. And it's important to know that, once that application's on file, potentially the protection's there for you overall, and certainly once it's published, you've got some rights. But people don't like stuff hanging around, do they? I mean, I think you're running a business. You don't like stuff hanging around and not knowing where you are. It's the uncertainty that's the difficulty.
Yeah, absolutely. I suppose just a question, actually, just in terms of time from filing to grant. Obviously, for me, I have clients, obviously, who are looking at getting patents to get into patent box tax relief.
Okay. Yeah.
Not necessarily, obviously there are many that are bothered about commercial protection, but there are some that aren't so much, but obviously want to get the tax relief. So they are looking to get something granted as quickly as possible. What at the minute, in terms of in the UK, how quickly, if you were applying for a very simple single patent, how quickly could you actually get one granted from filing?
So I think you could do it. You could do it in under a year, if it sails through search and examination. I think that's certainly been done. You'd have to ask for early publication of it.
Yeah.
But that's certainly
possible.
been done. Yeah.
That's really helpful. Thank you very much. John, over to you.
Just sort of staying in Europe briefly. Clearly, the the unitary patent and the unitary patent court have come into being. And I was speaking to a litigator, and he was quite excited about the unitary patent court because he felt the idea of having an injunction in 17 jurisdictions was very powerful. And I don't know how in such a short space of time, but he'd formed the view that the court was pro-patent and it was a simpler, cheaper process. And I don't know if you saw yesterday, one of Eric Spangenberg's deputies from IPWE is set up as a monetization business in Spain and started already to sue Google at the Unitary Patent Court. So it is a couple of questions built into that long statement, but what are your views on the unitary patent, and do you think the Unitary Patent Court will bring more litigation to Europe? Because traditionally it's been in the States.
Well, what are my views on the Unitary Patent Court? So, as president of the Chartered Institute of Patent Attorneys, we're seeing it as a really fantastic opportunity for patent attorneys, UK patent attorneys. So, strangely, the UK as a country is not in the convention. So, the Unitary Patent Court doesn't have jurisdiction in the UK because we're not in the EU anymore, sadly, in my view. But European patent attorneys, UK European patent attorneys can represent. And we've already got a large number of people that are active in cases, and it's a big opportunity from that point of view. And one of the things that I think it is doing, it is changing the landscape of where European patent litigation happens. So it used to be that it all happened in Germany, or a large proportion of in terms of numbers, a large proportion of patent litigation in Europe happened in Germany. And what's been seen is so cases that might have been brought in Germany are now happening at the UPC, and there have been reductions in German litigation. And our friends and colleagues in the equivalent profession in Germany, I think, are a little bit concerned about this. From the UK perspective, we've got High Court litigation, we've got the Intellectual Property Enterprise Court, all of those things that we had before, and now we've got the option of the UPC as well, which is great stuff. Okay. In terms of the unitary patent, I think it's good. It looks like good value to be able to get a patent in, as you say, in 17 countries on grant of your European patent. So get that unitary patent. That looks like good value. And in terms of whether it's going to move litigation from the US to Europe, I mean, so there is a suggestion that it might, and particularly the kind of MPE litigation. The attraction for MPEs is that injunctions are available, preliminary injunctions are available, but it's quite a fast process. There are strict timescales on the UPC process. And unlike the USA, there are also costs orders available. So if you lose, you potentially pay the other side's costs. Right. So I am... I think the jury's out on whether there will be more. I mean, there is already MPE litigation happening at the UPC. Whether it's going to move like that, I don't know. I think, though, depending on what the decisions look like when they come out, I could see it becoming a useful global forum for patent litigation, a forum of choice overall. But what we need to see is some sensible decisions coming from the judges.
Okay, I think it's really interesting, and
it is. Really what I'm wondering is, John, is there? Sorry, John. What I was going to just jump in. Obviously, I appreciate we've got a number of patent attorneys who are obviously on the call, and that will have all been, they will have understood what we've just been talking about here. But I'm just conscious that this is being recorded, and there may well be some businesses that may well be listening to this later. I think it might just be useful to kind of explain what we've been talking about in terms of what the court is and what the unitary patent is, and as in the previous system and how things have changed. Is it possible Without,
Would you like me to
yeah,
do that quick explainer?
yeah, sorry, but yeah, just
Okay.
very, very quickly, just for people that haven't necessarily
Yeah.
understood what we've been talking about.
So when you're filing patents fundamentally are national rights. There's no world patent. There is a European Patent Office, and the European Patent Office covers, I think it's 30 odd different countries of Europe. It goes beyond the EU. It actually goes beyond Europe as well. And you can file your patent application at the European Patent Office and designate all of those countries, get it granted centrally there. And in the old system, you then had to choose the countries in which you wanted to bring that into force and validate in those countries. Some of them required translations, a lot of them didn't, but you could bring it into force, and then you're paying renewal fees nationally in those countries. So you're turning it from a bundle of from a single patent application into a bundle of national patents. What the unitary patent does now is allows you to have one patent that covers these 17 countries. So it covers France, Germany, Italy, many of the major European countries. It doesn't cover Spain. It doesn't cover Poland. But it covers many of the major EU countries. And you have that in a single patent that you then pay renewal fees on centrally to the European Patent Office. And you've got more countries and more bang for your buck. And then along with that, there is the Unified Patent Court, in which you can litigate these patents, so you can enforce these patents, and you can litigate European patents as well in those countries. So the old style European patents, if they haven't been opted out of the system. And all of that should make things simpler and potentially more cost effective for enforcing patents. So getting and enforcing patents in Europe.
That's really helpful. And just to carry on Caroline's line of questioning for the non-patent attorney professionals on the call, what makes an invention or innovation patentable?
Right. Well, I mean, so very basics. If you're going to get a patent for an invention or for an innovation that you've created, then it has to be absolutely new. So that means never heard of anywhere in the world ever before. So and the implication of that is that you need to keep your innovation secret until you filed your patent application. That's the basic rule. So if you've launched the products, it's out there, it's in the shops and it's being sold or whatever you're doing, then potentially you've lost the opportunity for patenting overall. So that's the bright line test. Is it new? That also means is it new? So if I always use the example, if a yak farmer in Mongolia has been using this product out on their farm where everybody could see it, then that could stop you getting a patent. So it's anywhere in the world. And the other thing to remember, so there's a patent database from the European Patent Office called a SPASnet, and that includes millions of patent documents. And even if you're in a business where you think, well, I kind of know what's in my industry, I know what's around there. The EU is estimated that 80% of information is only available from patent documents because they're such a detailed source. So it's a good idea looking around that before you commit to a patent process. There are other requirements. So there are categories of things that aren't patentable. So there are things that we would think of as technology. There are things that we would think of as innovation that aren't going to be patentable. Things around business methods, some things around software. I will always say, get some advice from a patent attorney. If my test for a company to understand whether they've got something that they might want to patent is not really about the law. Is it new? And would you like to be able to monopolize that? Would it be useful to you to be the only people that can do that thing, produce that product? And if your answer to that is yes, then go and talk to your patent attorney about it. The legal test, you're required to have an inventive step. That means that even though it's new, it's got to be sufficiently differentiated from what's gone before to justify a patent. But again, You get people working in technical areas going, I can't believe we're not going to get a patent for that. It doesn't feel very clever. It's a legal test, and part of the job of your patent attorney is to pass that legal test. So again, never decide, I can't believe it's new. We know it's new. I can't believe we can get a patent for that. Well, don't decide that you can't without taking a bit of advice, because if that monopoly would have been useful to you, you don't want to throw it away because of your own judgment on that.
Yeah.
I suppose a question many businesses will, who don't know anything about, they've not entered the sort of IP foray yet, will want to ask is, when's the appropriate time to actually go and see the patent attorney? Is it when you've got the idea? Is it when you start doing R&D? Is it when you start making something? What point is the best time to actually come and see a patent attorney?
I would say as early as possible.
Mm-hmm.
I think. Yeah, as early as possible. So I guess you can be in a situation where you're thinking, all right, it'd be great to have a product like this. Yeah, that can be the first step. One of the things that you could do at that stage with the help of a patent attorney or with the advice of a patent attorney, you might be doing it yourself, is you say, oh, it'd be great if there was a product like this. Have a little look around and see what else went out there. You often find that people have been down this path before. And then you've got to ask yourself a question, well, why is that not turned into a big product? Why am I not seeing this on the market? Other people have thought of it. And it might be that they had rubbish businesses and couldn't bring it to market, or there just might be a fundamental issue with it. Although things change, technologies change, and the things that you might be using to enable that invention might now be available when they weren't before. And then, so as you go through that development process and you solve those problems and you're getting to the point where you've got a product that you think is actually going to be turning into a saleable product, then before that, you want to have at least got your patent filing strategy in place and had the advice on that.
Yeah, and I suppose just obviously you've mentioned software. Obviously we know that software is not, strictly speaking, patentable, but nevertheless, there's plenty of software that is. So can you just, there's a question here that John's framed around AI. Obviously, AI being a massively hot topic. I mean, what sort of trends are you seeing at the moment in terms of software patenting or patenting AI? Are there any kind of trends or pitfalls or things that you're seeing, issues with patenting that kind of technology?
Well, I think so. There are lots of patents for AI models, so mechanics of AI, doing better AI. I think the challenge for patenting comes as a business. You say, oh, we're doing this, and what we'd like to do is we'd like to use some AI engine to enable part of our business, to automate something or to do something better. So if you're taking a part of your business, you are educating a model with known data to do something that is known and just automating that. I think you're going to have challenge, although that will feel like innovation to you. I think you're going to have challenges around patenting that, because I think it will be seen to be obvious. It's the old, I mean, it used to be the test of a mere automation, that kind of thing. But technology will develop, and I'm not. I mean, there have been headline-grabbing questions about inventorship. Something invented by AI. Well, yes, but that's in my view that's a game that's being played in there. It's not. I don't see it as a reality. If you have if you have a machine that turns out products and you look and say, oh, okay, we should patent that product. It's not what you expected when you put it in. I use the example of back in the day when chemistry was the hot technology. When you knock over your flask and you've created a brand new plastic by accident, you're perfectly entitled to patent that in there. It wasn't the flask that created it. It wasn't the piece of kit that created it. You're entitled to be the inventor of that. It's because you set up the experiment to do that. And I think the sensible approach, what I'm expecting to see develop, is the sensible approach is when you set up the AI to generate this, then yes, you can be entitled to be called the inventor in that situation. That's how I'm expecting the law to develop. At the moment, there are distractions and there are the interests of those that would like to see that appear to be more complicated than.
That's a quick one. Further question on AI.
Yes.
How is the patent attorney profession embracing AI to help you do your day to day? And what further changes might there be to the patent attorney profession from AI going forward?
Well, I think with new technology like this, everybody it's the first thing that said is like, all right, everybody's jobs on the line. And I'm old enough to remember when it was like, oh, there are going to be computers on the desktop, and so everybody will be unemployed because we have computers on the desktop. Now, of course, everybody works in IT, so it's kind of generated more work, and there's always a situation that people are on a timescale of 30 years or something. People are now working in industries and jobs that didn't exist 30 years ago. So I'm not concerned about AI removing the need for a patent attorney overall and patents being automatically written by AI. That doesn't worry me. What I think, though, is it's a tool that you use. There are parts of a patent application that are more onerous and are more apt for automation, and that will happen. And I've already seen demonstrations of tools. What, of course, is incredibly important, as everybody knows that's used any kind of AI, is you need to check the results. I don't know if you heard the story of the guy that used AI for his court case in New York, with a list of cases that he cited, and 3 of which didn't exist. And he hadn't checked. So you now have to check the results, and it's a tool to advance you. You might get a first draft of a patent application, but ultimately, as a patent attorney, you're signing it off. One of my concerns, though, is it potentially changes the workforce. So we're very successful in the UK at training new patent attorneys, and one of the things that as part of that training is that you're using junior patent attorneys, fresh graduates that are bright, to do things like review patent documents. Come to me and tell me what's in these patent documents. We're looking for this. Tell me where you found it, where you haven't. What does this say? And doing that, it's good. It's cost effective for the client. Potentially, you can stick that into an AI and have that done and answer the same question. So those opportunities might go, and I think that's going to change the model of charging as well. So charging by time. The client's still getting the same value because you've got trained AI, but you can't say, oh, it took my assistant 50 hours to do this. So we're going to have to look at what I would call value-based pricing, but I think people are already doing that. So it's definitely being embraced. I've seen lots of good demonstrations. The important thing is, though, that you're still going to have to do what you do as a professional advisor, and in the end, what people want is someone to sue. And if you think about but ultimately, they want someone to take responsibility for it. That's what I'm saying in terms of someone to sue. And if you think we've had the technology for a very long time to have self-driving cars. Cars can drive themselves. The technology is there, and they're probably better drivers than humans. But they're not on the roads, and they're not on the roads because no one knows who they're going to sue when someone gets killed by that car. That's the major challenge. It isn't a technological one; it's a legal and ethical one. And the same applies for your patent attorney that's AI assisted. Yeah, you just sign them off.
Yeah,
there you go. That was a long answer.
Great answer, thank you. Caroline, if there's any further questions on that, otherwise, I just wanted to touch on the UK IPO survey because we have referenced it several times, and we did discuss it prior to the call. So my summary of the results, by the way, is 21% of those surveyed SMEs surveyed had a registered trademark, 28% used copyright, 14% have a patent, 15% use trade secrets, 19% use NDAs and confidentiality agreements. It was published, I think, about a week ago by the UK IPO. It's well worth a look at. And the sort of balancing factors Matt's already alluded to is maybe some of the stats, 30% using Google, don't really make sense. But I think also, as Matt pointed out to me just prior to the call, 60% were small companies or micro companies or one-man businesses. And the likelihood of them having a trademark at an early stage is quite low, certainly if it's just a one-man business. So, it's a good context to that, but it gives you an illustration, I think a fair benchmark possibly of what's out there in the UK SME space at the moment by way of understanding of IP. Caroline or Matt, any further comments on that before we move on?
I like that they said that 60% of businesses that use IP have an IP strategy to manage it. I thought that was great to see.
Yeah.
The most interesting thing that I thought in there was so there was a question about understanding familiarity with IP. So that increases with the size of the business. So larger businesses tend to be more familiar with IP than smaller businesses, but the familiarity was pretty high overall, about 80%. But then understanding went down. So when they tested the understanding of different IP rights, that went down for the larger businesses. And I thought, okay, what's that about? And then I guess my guess for that is that's the larger businesses have people that do that for them. They're engaging the professional advisors, so they're not understanding that. And I tend to think that that's the right thing. All you need to know is when you need to call your patent attorney, when you need to call your trademark attorney. You don't need to be intimately familiar with the law itself. You just need a good advisor, like so many things.
Fantastic. Thank you. Caroline, have you got a question or shall I ask Matt about innovation and Zoom?
I think you should ask Matt about innovation and Zoom.
So last week, Matt the CEO of Mike, and there's an inexorable, I think, move back to the office. I was just speaking to somebody yesterday who was 1 day a week in the office, and she's changed company, and now the minimum is 3 days in the week in the city. She's in the insurance business. The Nike CEO said whilst we did innovate when we were on Zoom over COVID times, lockdown times, it was incremental rather than breakthrough innovation. We need breakthrough innovation. So it's pretty much forcing people in a way back into the office if they want to be part of the innovation program at Nike. I just wondered what your thoughts and even your experience was during lockdown in particular, but subsequently since as well. Can you truly have breakthrough innovation on Zoom? What do you think, Matt?
No. I mean, I've done long answers. I mean,
10 minutes to ask the question. You can only say something more.
So I think what the pandemic did was demonstrated that you can do lots of parts of jobs effectively, remotely, from your back bedroom on Zoom and everything else like that. And what post-pandemic, what we're learning is, but there's a bunch of other stuff that we're not doing now. So it's not just innovation. There are the ways that companies interact. There are ways that companies operate, and the things that come from being in the same space together, whether you want to characterize it as water cooler moments or anything else like that, the sense of belonging to an organization, all of those kinds of things. And because companies survived during the pandemic remotely, you're inclined to say, well, that's brilliant. We don't need to do any of that. But now you're going, oh, actually, but we don't do this anymore, or this hasn't happened, or we're not retaining employees, or we're not doing those things. And I think innovation is one of those. And it's it's almost like a scientific experiment, isn't it, to shut down a part of thing and see what's missing. But it takes a while to realize that it's not there. So yeah, there's a bunch of stuff that is important to a business and can't be replicated remotely. We are after all people, and people like people.
I think it's a great answer. I do think it's a great answer. And clearly there's a lot of margin connected to this as well. I don't know if you're aware, but there's some ultra fast running shoes that Nike and and Adidas have brought out. And the world record for the marathon was broken on the Nike shoes. But the difference between the shoes that I buy for running and those shoes is about a matter of about another £250. So, clearly there's a good margin to be innovating or having breakthrough innovations. If you can shave, 4 seconds or 4 minutes off your marathon time, then it's worth it to some people, but maybe not for me.
John, do I look like a man that's familiar with ultra fast running shoes?
As a technology expert,
Oh, okay, maybe as
innovator,
a technology.
president of the UK patent attorneys, and you are probably very fast with the chords on your guitar as well, Michael. Wouldn't it?
No.
I would imagine as well. Right, Caroline. Questions from you? Questions from me?
Well, I want to give you time. I'm just kind of conscious we've got 10 minutes left, and one of the next questions is about what's all the fuss about trade secrets. And I know this is a massive thing for you, John. So I'm not going to steal your thunder. I think you should crack on and talk about trade secrets with Matt.
Well, I think you've asked the question. Is there a fuss about trade secrets, Matt? How do trade secrets interplay with patents? What's your perspective on that?
Well, of course, the classic bit of advice is you can't patent an invention and keep it secret. Inevitably, as part of the patent application process, even if you don't get a patent, you're going to have to put that information into the public domain. It's the way the patent deal works. You can have a strategy where you have parts of your technology are protected by patents and parts include trade secrets. So in how you implement that, and that's a sensible strategy. And I think the fuss is just that there has been more formalization of the law around trade secrets. Oh yeah, it comes down to some of the basics of IP strategy, doesn't it, John? Of saying you need to have a look at your business, understand what your intellectual assets are, what are those things, and then work out how you protect them. That's what the intellectual property rights are there for, and that's where you get intellectual property. But you've got things like, your people and your employment contracts, and those are intellectual assets of a business. You've got your knowledge of the markets, you've got your customer database, you've got all of those kind of things, and having a sensible idea and recognizing that those are valuable to the business, and then understanding how they're protected. And one of the ways of protecting them might be by keeping them secret or having them contractually protected in some way so that they can't be used by other people. Ving?
Yeah. Perfect. So we're now jumping into Caroline's domain, but rather than Caroline asking the question, I'm going to ask the question. There's been a lot of stuff in the press in the last year, at least, about R&D tax credit reforms. What is your perspective on that? And I'm particularly interested as to whether you feel that that's having an impact on innovation or having an impact on innovating businesses applying for these reforms or benefiting from these reforms. What's your thoughts?
Well, Caroline's the expert on applications for the R&D tax credits. The only thing, so as a patent attorney, I've always thought that there are more opportunities to marry up the R&D tax credit application process and the patent protection process. So the model that's been used in the past by a lot of companies for R&D tax credits is that the credit itself will pay for the fees. So that's very attractive. It's a good model in there, whereas patent attorneys tend to be paid for their time. So if you're able to take tech-savvy, capable graduates, put them into a company, get them to look through all the things you're doing and identify the bits where you're innovating, where R&D tax credits might apply, and put that into a report, giving that report to a patent attorney and saying anything we might patent in that is ideal. So I see a synergy there And I don't think, in my experience, that's happened as much as it might. I think there are real opportunities there to marry that up.
Yeah, absolutely. I said that so we had a chat about it on the call before. There's definitely a synergy between the tax definition of R&D for sure and the legal test for patenting. Just for the benefit of people on the call that might be businesses that kind of aren't aware. Obviously, the tax definition of R&D is that R&D takes place in a project where the aim of the project is to advance science or technology through resolving technical challenges or uncertainties to the competent professional in the field. So that's the tax definition, and the legal test for patenting. I'm not going to defer to Matt in case I get it. I do know it, but it's I should ask you to tell people what the legal test for patenting. I think you've already been through it already, so if you can just kind of remind people.
Well, I mean, it's going. I mean, it's not going to fit as simply into one sentence.
No, I
like
know
that. But you've got to have something that's new and inventive according to the legal test. But you can see, if you draw the Venn diagram of the things that are going to meet the patenting definition and the things that are going to meet the R&D tax credit definition, you can see that they will be very closely aligned.
Yeah, exactly. The novel and inventive steps, very similar to proving an advance in science or technology that we have to prove for a successful claim for R&D tax credits. So absolutely. I suppose just obviously companies, what we're talking about in terms of the changes to R&D tax rates. I mean, John and I did a webinar which has been recorded, which people are going to listen to, but there have been wholesale changes, for accounting periods from the 1st of April this year. There's a new combined scheme. So the old SME R&D scheme's been abolished. So is the old RDEC scheme. There's now the new combined scheme for companies of all sizes. And there's also a separate scheme for R&D intensive loss-making SMEs as well to claim under. So the beneficial rate of tax relief for R&D has altered. But also it's about compliance as well. And there's a whole lot of different sort of compliance requirements that come in from HMRC, and HMRC has increased the number of compliance checks into R&D tax relief claims. There's a lot of, their HMRC's current approach is very controversial. There are a lot of companies having quite a hard time with claims that have been put in for R&D tax credits where it is genuine innovation. The tax definition has been strictly complied with, but nevertheless, they're facing compliance checks that they just can't, find it very difficult to get HMRC to accept their position. And that is, unfortunately, I know from speaking to some companies, having a knock-on effect on whether or not they actually want to claim in the future. It might not be having a knock-on effect on whether they want to claim R&D, whether they're actually going to innovate, but certainly whether or not they want to actually pursue a claim for R&D tax relief, which is unfortunate because there are companies that have heavily relied upon the money they will get for a successful claim to actually stimulate innovation going forwards. And there are unfortunately some other changes as well in relation to subcontracted expenditure. Restrictions on if it's overseas, whether or not that can be included in a claim going forwards, which is resulting in some companies actually deciding to move their operations from the UK overseas. So it's these kind of things. They are unfortunately not been that well received, certainly for innovative companies going forward. So that's what we were talking about in terms of the R&D tax credit reforms. Some of them are necessary, but there we are.
But I guess it's the same situation for a business. What you need is good advisors that you trust, and they will be able to get the best for you in that situation.
Yeah, that's a great summary from today's call, Matt. Just looking at the clock there. So, good advisors who you can trust, patent attorneys, trademark attorneys, people like Caroline who know the R&D tax credit and patent box system inside out. Contact them at the right time, and it sounds like earlier is better than later.
Yeah.
So, Matt, it just behoves me to say thank you very much for your time. Really good call. Really appreciate it.
Pleasure.
I really did want to be able to play your music as we introed and as we extroed, but I'm just going to quickly say you are playing on the 11th of May. You generally play in South East London. There are rumours that you might be going to Manchester soon to play it
on our world tour.
In a world. But for those who are interested, Ronnie Ripple and the Ripcords are a high energy, good time rock and roll, skiffle, and rockabilly band playing covers and originals. And I'm just right. Just bear with me 1 second. I'll just say goodbye. I am going to try and play. So just see whether it's going to work or not. It probably won't because it wouldn't earlier. But let's just see.
Oh,
Not that document, John.
Yeah, no. So I'm trying to do it through the document rather than through. But I don't think you can hear that, can you? I don't know why.
No, but there's our Spotify EP.
Yeah. So there it is. This Girl of Mine. That's your EP. So Matt, again, I'm sorry I couldn't play your music because it's really good. Carol and I listened to that yesterday, and we thoroughly enjoyed it. So that's a real shame. Very good. Let me know because I'm based London-ish. I'm coming to your next gig or one of your next gigs, and Caroline and I will see you in Manchester when you do your world tour.
Lovely.
Definitely.
Thank you very much. It's been a pleasure.
Thanks, everybody.
Thanks
for
very
joining
much,
us.
Mark. Thanks,
Cheers now.
John. Bye.
Thank you.